Now let's back to volume 3A, page 20. Yes.
Volume 3A.
Volume 3A, page 20.
Yes.
And I was referring to that sentence. There was no Aligarh University existing till 20 Act was passed. It was brought into being by the 20 Act and must therefore be held to have been established by the central legislature, which by passing the Act incorporated. The fact that it was based on the MAO College would make no difference to the question of who established it. That's where they went wrong. So he accepts that it was based on the MAO College, but he says it makes no difference. So now let's come straight away to page 21. And that page 21, that's Placetum, last paragraph. Yes. Last paragraph. Let's have that. From the history we have set out above, it will be clear that those who were in charge of the MAO College, the Muslim University Association, and the Muslim University Foundation Committee were keen to bring into existence a university at Aligarh. This is the admission. There was nothing in law then to prevent them from doing so if they so desired without asking the government to help them in the matter. So they accept the fact that, yes, we are the ones who wanted to bring a university into existence. It was the minority community. But if they brought into existence a university of their own, degrees of the university are not bound to be recognized by the government. So that's 21. Placetum G. It seems to us that it must have been felt by the persons concerned that it would be of no use bringing into existence a university if the degrees conferred by the said university were not to be recognized by the government. So in fact, Bashar sets out the reason why we went. So that's on 21. Now, these are the correct statement of facts in Bashar, which I pointed out. Now, the incorrect statements of fact. I'll just point those out. First of all is page 23. The incorrect statements of fact. Paragraph 2 in page 23. Yes. It says, that's Placetum between B and C, sentence C, it will thus be seen. Your Lordship has that? Paragraph at page 23. Second paragraph, it will thus be seen, just above Placetum F, that besides the fact that the members of the court had to be all Muslims, there was nothing in the act to suggest that the administration of the Aligarh University was in Muslim minority as such. Correct?
Where are you reading, Mr. Sibyl?
This paragraph, page 23.
Yes. Besides, there were other bodies, that para?
Yes, in that para, 5 sentences thereafter, it will thus be seen.
Yes.
It will thus be seen that besides the fact that the members of the court had all to be Muslims, there was nothing in the act to suggest that the administration of the Aligarh University was in Muslim minority as such. Besides the above, we have already referred to section 13, which showed how the rector, namely the Governor General, had overriding powers. This is completely wrong, Mullah, because the overriding power is in every university in the hands of the visitor, whether it is the rector at that time or the visitor now. In every statute, whether it's qua minority, qua majority. The overriding powers are there always, Mullah. But that's not the test. Yeah, Mullah, I'm sorry, my learned friend is right. I missed it out myself. Page 21, end of the page, Mullah, it's my fault. The hurry, I'm missing out things. Placetum H, Mullah.
Maybe accepting.
It may be accepted for the present purposes that MAO College and Muslim University Association and Muslim University Foundation were institutions established by the Muslim minority. Accepts the fact. And the two of them were administered by societies, of course. That's normal. Therefore, 23 is this one fact, which I showed to your lordships. Then kindly come to page 11. I mean, sorry, not page 11. Page 11. Back to page 11. That's incorrect facts. It says, Mothers, there is no condition. Mothers, placetum between G and F. Last sentence in the second paragraph. There is no condition that the Lord Rector and the members of the visiting board must belong to the Muslim community. Well, how is that relevant? Can it be said that the Governor General of India must belong to the Muslim community? I mean, what? Or for that matter, the Chancellor must belong to that community. In present circumstances, how can anybody say that? There is no condition that the rector and the members of the visiting board must belong to the Muslim community. So that's Malad's ex facie wrong. Then come to page 13. This again I'm sorry. This again shows. Yes.
At the bottom last, this again shows. Last on the page, 4 lines, this again shows. On page 12, sir, on page 12, right at the.
Yes. Page 12, Malad. You put page 13. That's now what?
Oh, yeah, it is. This shows the.
Where is it?
Can we cut? We have understood. We have understood.
Yes, now Malad, just see page 13. Placetum A and B. This again shows that in the matter of such disputes, the court, which is called the supreme governing body of the university, did not have the power to resolve it. Whereas if the dispute is between the academic council and the executive council, they say there was no power in the court to resolve it. Well, how does that, what's that? Because arbitration was provided for. How is that relevant for the purposes of establishment?
All right.
So that's 13. But just one or two more things. Then Mullahs, kindly come to page 13 at the bottom. There is nothing anywhere in any section of the Act. Where is it?
Second line.
Yeah. There is nothing, Mullah's last paragraph, second line, there is nothing anywhere in any section of the Act which vests the administration of the university in the Muslim community. The fact that in the proviso to 23, it is provided that the court of the shall consist only of Muslims does not necessarily mean that. Now, Mullah, this is factually incorrect, and your lordships may note that. In the academic council, 15 members from the court are from the court, which are Muslims. Factually incorrect statement. Page 19. Your lordship may just note that. Page 19, volume 3. In the EC, 20 out of 30 are elected by the court.
Just give us the date, figures again.
Yes. In the academic council, 15 members are from the court and are all Muslims. That's at page, because at that time court were all Muslims. That's page 19, volume 3G. And that's the academic council. In the executive council, 20 out of 30 were to be elected from the court, all Muslims. That's 2/3. And 6 were to be elected by the academic council, which were also Muslims. and VC and PVC were to be elected from the court. They were also Muslims. So for him to say that there is nothing anywhere in the section which vests the administration, is so factually so incorrect from the act itself. It's not outside the act. One is at page 19, the second is at page 21, and the third is at page 11, page 11. The AC is at page 19, EC is at page 21, and the control is at page 11. Control was of the minority community. So that is factually incorrect. The next one, I will forget. The next one, page 18, Malas, right at the top. We have to examine closely what happened.
We have already-
Malas, we have already all, so therefore forget that, Malas. I've already said that. Then page 19, Malas, second paragraph. There is nothing in the 20 Act to prevent the Muslim majority, if it's so minority, to establish a university. But if it did so, the degrees of were not bound to be recognized. Already said that. And then, Malas, he said, it may be that page 20, that the 20 Act was passed as a result of the efforts of the Muslim minority. But that does not mean that the Aligarh Muslim University came into being. That's it. It's at page 20 itself, Malas. It's contradictory. Page 20, Placetum, D, Malas. Yes. It may be that the 20 Act was passed as a result of efforts, but that does not mean. So that takes care of that. Then page 22, Placetum, E, C. It was thus, that's one. It was thus the central legislature, Placetum C, which brought into existence the Aligarh Muslim and must be held to have established it. That's the basis of the order in any case. Then right at the end, last paragraph, it appears from paragraph 8 of the schedule that even though the members of the court had to be Muslim, the electors were not exclusively Muslim. That's neither here nor there. I've already shown that, Your Lordships. Then page 23, first paragraph, last 3 lines. Further, 15 members of the court were to be elected by the Academic Council, the membership which was not confined only to Muslims. Sure. Then page 23, these provisions in our opinion, Placetum, Placetum between F and G. These provisions in our opinion clearly show that the administration are not relevant, really speaking. We are on administration. So really that takes care, Malas, of what was right and what was wrong. So, Malas, I've done that. And the last thing now, then I've done it. What is the last thing? What is it that we brought in and what was transferred to Aligarh Muslim University? 1, 30 lakhs.
Just one second.
Yes, government at that time asked us to bring this in. 30 lakhs raised by the Muslim University Association, which is worth 300 crores today. In 2005, it was valued at 287 crores. This is reflected in Section 7 of the 20 Act. Section 7 of the 20 Act, Volume 3G, at page 7. Section 7 of the 20 Act, Volume 3G, at page 7. So founded. That's what Dr. Dhawan Malas kept on saying. It was founded. So the sponsorship is ours. We sponsored it. All land, infrastructure, movable, immovable properties of MAO College and the Muslim University Association stood transferred to AMU. So all land, all infrastructure, movable, immovable properties of the MAO College and the Muslim University Association to transfer to AMU. So all the assets, movable, immovable, all transferred. That's at section 4.1 of the 20 Act in volume 3G at page 6. Section 4.1 of the 20 Act, volume 3G, page 6. The next is even more important. Any property given to the MAO College or Muslim Association by gift, trust, would be read as will gift to MOU. Kindly see, this is a private, your Lordship knows. A will is a private act, and a private instrument. Even that is deemed under the act to be given to be a gift. Even government land becomes theirs, This shows continuity, This is section 4, small Roman 4 of the 1920 Act. Section 4, small Roman 4 of the 1920 Act, volume 3G, page 6. Then, all buildings of MAO College. Next, all buildings of MAO College were to vest in the AMU. And the same name were to be kept of those buildings. Names could not be changed. That's, section 4, Roman small 5 of the 20 Act.
Section 4.
Small Roman 5 of the 20 Act, volume 3G, page 6. Then, 5. All employees of MAO College transferred to AMU. Yes, shows continuity, all this shows. This is volume 4, Roman small 6 of the 20 Act, volume 3G, page 6. All employees and all students of the MAO College permitted to complete their education in the AMU. So students were transferred, again, continuity. That's section 32, brackets 5 of the 1920 Act at page 14. So this is how, the continuity is established, the genesis is established, the foundation is established, and Basha acknowledges all this, but it says doesn't matter because there's an act. It matters. Matters because this is the only institution of its kind set up with intent to serve the interests of secular India and to protect the minority institutions in empowering their children and others to be part of the workforce of India. If you reject this, you destroy that dream. That dream should not be destroyed. Thank you very much.
Thank you, Mr. Uppal. Yes, Mr. Khurshid?
The Lordship may pardon me for a while.
Yes.
Any further note? Okay. Things in like.
Please, Your Lordship. Lords, I adopt whatever my learned colleagues have said, Lords, with appreciation and gratitude. I'm only picking out some first principles, my Lords, that would, I believe, assist Your Lordships in coming to a conclusion, which essentially, as I understand, is simply in the backdrop of whatever has been explained to Your Lordships, whether the establishment word used in Article 30 leads to a situation in which everything is there except the actual act of establishing it by an act of parliament. Does that take away? So, my lords, essentially, there are three propositions that I'm placing before your lordships. My lords, very, very briefly, in a few minutes, the backdrop of Aligarh Muslim University. My lords, the lordships have been told how Sir Syed Ahmad pursued the establishment first of an MAO college, and then his followers pursued the establishment of the university. Well, the matter begins with 1957, and the Sir Syed wrote out this great book, the treatise about the reasons for the uprising, the mutiny, or what we call independence, the war of independence, the first war of independence. And thereafter, one of the important causes for him, as he found, was the backwardness of Muslim community, particularly the educational backwardness of the Muslim community. So he set out to bring about education. He had already set up something called the Scientific Society, the purpose of which was to translate scientific books into Urdu so that they could be made accessible to the community and make the community more aware of what the scientific developments were happening. And that was Sir Syed. He then, my lords, after 1857, he visited Oxford University. He tried to absorb and understand how a good university could be made. And then, of course, the same designs of Oxford University were reproduced in the architectural plans of what was MAO College and then Aligarh University. Of course, we didn't have colleges as Oxford and Cambridge have, but the buildings were designed around what are called halls of residence. It was to be a residential university, so there were halls of residence, each hall having very eminent background and each hall having a particular character. So, my lords, there is what is called in Aligarh an Aligarh Tehzeeb. It's very important. And I'm saying all this, my lords, because I have a sentimental attachment to Aligarh. I was born in the Vice Chancellor's house, and therefore I do have a claim sentimentally on Aligarh. But be that as it may, my lords, there's a particular Tehzeeb translates into culture or a subculture that Aligarh represents. I do believe there's a culture in every great institution. Lordships know culture in every great institution, but Aligarh has a unique culture, which a great deal has to do with ability to speak, ability to propound, ability to interact, ability to imagine, and to project. My lords, this is seen right through the Aligarh University's culture. My lords, so when the university is established, your lordships have also already seen that it was established with the effort of the community. And therefore, I distinguish in first principle two kinds of establishments. Well, two kinds of statutory acts that may be propounded by government. One is a non-consensual act, where, my lords, an institution that has fallen on bad times, where there is widespread talk of corruption, that people are not being served as they should be served. And the government steps in to say that in order to save this institution, we need to take it over. And they take over that institution. It's a non-consensual necessarily. But there can also be a consensual takeover, which is exactly what Aligarh was about, where everybody gathered and said, please convert us into a university. And as Mr. Kapil Sibal just argued, all those assets and the entitlements of MAO College were handed over to the university. Well, two things have happened. When Aligarh Muslim University Act was passed in 1920, it was not assumed that there would be a difference between two different kinds of universities, which we now have become familiar with, private university and a public university. Your lordships asked what minority institutions or university level institutions are there. And it seems that Aligarh being one, provided your lordships agree with us, Jamia University is the second one, dependent on whatever the decision will happen in Aligarh. Jamia was a breakaway offshoot of Aligarh. Jamia was part of the independence movement, because in the independence movement, it was felt that whatever
Khurshid, we're not dealing with Jamia's case because that's a separate matter. So if you want to go into that, maybe expanding the scope of the reference.
Well, I'm only saying that your lordships asked me if there were more than Aligarh institutions that were likely or felt to be minority institutions. Jamia is one, but that's also in litigation, and I do believe in the High Court.
Apart from Jamia, any other Any other examples in the country?
Well, it's the
Just
other
out of
example.
curiosity.
There are other examples. In fact, the other side has produced some examples. Those are all so-called private universities. Well, there's the Mahavir Jain University. There is the Christ University, Christ College. Your Lordships mentioned Vellore Medical College. Now, what has happened there is most of the Christian institutions either are like St. Stephen's College within a larger complex of a university, or they are all deemed universities. So, Millards, if you start with a school, you start with possibly a society that is registered under the Registration Act. From the society, you develop a college that is also under Registration Act and whatever affiliation is provided. The college then could possibly become deemed university. Nothing happens. The character is preserved throughout. It's just the transformation from a deemed university to a full university when the question marks come. Your Lordships asked about Jamia. Jamia retained that character without any question while it was a deemed university. The moment Jamia became a full university, Jamia also came under the same question mark that now is placed before Aligarh University. So, my lords, the private universities are there, but just for your Lordship's information, the private universities that are treated as minority institutions has a slight tweaking from the model of Aligarh. Well, Aligarh model was that everything that was owned by the societies was handed over. Jamia did the same thing, was handed over to the university, and the societies were dissolved. What the private universities now are doing is that the society doesn't get dissolved. The society retains whatever it has, but the society comes under the umbrella of a university, and the society is told the conditions, once they are met, the government should be informed that the conditions are met, and on meeting those conditions, the university will come into operation. So today, the dichotomy is that you can have a private university, provided your Lordships at some stage in this matter or elsewhere hold that just the fact that the university has been established in inverted commas by an act of parliament or an act of the state legislature will not deny it its minority character. That finding hasn't yet come. But if there is such a finding, then private universities would exist. But as far as we understand, from our point of view, if your Lordships decide against us and in favor of Aziz Basha, as decided by the bench of 5 judges, then we couldn't, one way or the other, get a private university or a public university that would have the tag of being a minority university. So that's very critical. And well, for this purpose, what I'm asking your Lordships to do is to consider that when a society is registered, you can get together and could be a group of people, unorganized people, etc., can set up a school. But in order to get legal identity or legal entity or legal personality, they have to register themselves as a society. And the registration is under a statute. The registration is an act, the lowercase act ACT of the government or of the state, and yet it continues to be recognized as a private university. Here, the moment you go beyond a deemed university and you ask for being made into a full university, your Lordships have already heard it can only be done through an act of parliament, and therefore the moment it's done through by act of parliament, you lose your. So you're giving by one hand under Article 31 and taking back by the other hand by saying, well, if you're constituted or you are established or you're formed. So if your Lordships were to use the meaning of founded, it would be easy to then come to a conclusion that founding involves a participatory inclusion of the sponsoring society. In the private universities, they are now called sponsoring societies. Whereas here, your Lordships saw the history. My Lords, my second point would be a brief point.
Yes.
As your Lordships have noted, and the Aziz Basha judgment has also noted, MAO College was a minority institution. There is no doubt about it, and your Lordships have been shown all the indicia for something being a minority institution. Well, it's just a brief point related to this. The actual administration could well be part of the indicia to decide whether it's a minority institution. But it may well be that an institution that is to be administered after it's come into the status of a university may have an extent of regulation by which the administration, the free administration, may be restricted to some extent. That will only be enabling provisions restricted by, in terms of reasonable restrictions. But that may not have any reflection on whether it is a minority character or not. If it is a minority character, the restriction will be limited. If it is not a minority character, maybe the restriction will be more liberal. But my lords, TMA Pi has indicated that where there is an unaided minority institution and an unaided private university, private institution, which may not be a minority institution, the difference in the extent to which you can regulate is very limited, Maximum freedom must be allowed to in educational institutions. And what the maximum freedom that is needed for a minority institution is to carry the flavor of the minority institution, the culture and ethos of the minority institution. My lords, that is very, very critical. Then, my lords, if your lordships will turn just briefly to my written submissions, because your lordships will see it in 1B. I must apologize, my lord, there is an article that because of some technical difficulties attached to this. It's an article which only indicates the request that your lordships look at this matter in a particular manner in which Ronald Dworkin has described it. So, my lords, your lordship will see in the backdrop of what I told your lordships about Aligarh, your lordship will just see there the second paragraph. It's very important, historically very important. Your lordships will find this in Mr. Noorani's book, which is in volume 3H. This is taken from Mr. Noorani's book. Your lordship will see the second paragraph. The way Aligarh participates in the various walks of national life will determine the place of Muslims in India's national life. The way India conducts itself towards Aligarh will determine largely, yes, that will determine largely the form which our national life will acquire in the future. Well, this is a statement made at a stage when Dr. Zakir Hussain was Vice Chancellor. And having said this in the presence of the President, Dr. Rajendra Prasad, who was visiting the university. Well, it was Aligarh University from the time of Prime Minister Nehru to the time of Prime Minister Modi has a rich legacy of how the top leadership of the country has seen Aligarh. Time of Nehru, Nehru came and asked whether Aligarh didn't have a tarana. It didn't have a song of the institution. And promptly, that very night, a student inspired by what Prime Minister Nehru had said, his name being Majaz Lakhnavi, he grew up to be an outstanding poet of this country. Majaz Lakhnavi, then a student, alumnus of the university, sat down that night and wrote out the tarana. Well, if your lordship will permit me just 4 lines of that tarana, just to give you a flavor of how the community and those who participated in education at the university actually saw that university. Just 5 lines, Baloj. I'll translate any word that might be different. Ye mera chaman, ye mera chaman, ye mera chaman hai, mera chaman, apne chaman ka bulbul hum. I am the nightingale of my garden. This is my garden. This is a chaman that I belong to. Jo tare haram mein roshan hai, wo shamma yahan bhi jalti hai. The light that you find in the Haram Sharif in Medina is lit here as well in this university. Is dash ke goshe goshe se ek juए hayat ubalti hai. From every spot in this garden, there is a stream that flows, and that stream is the stream of life. Ye dashte juno divano ka, ye bazme wafa parwano ki. This is a place of passion of those who are passionate about what Aligarh is. And this is also the place from where we rise like a parwana. We rise and fly high up in heavens. ये शहर तरab रूमानों का, ये खुल्द बरी अरमानों का. Essentially, basically, this is the citadel of those who have aspirations and those who have dreams. फितरत ने सिखाया है हमको, nature has taught us here कि उफ्ताद यहाँ, परवाज यहाँ, begin your life, learn to begin your life here, learn to fly high from here. गाए हैं वफा के गीत यहाँ, we have sung the songs of faith here, छेड़े हैं जुनू के साज यहाँ. This is where we have started the lyrics of wafa, of faith. So, beloveds, this is the flavor. This is the flavor caught by Majaz, but this is the flavor that all of the Muslim community felt about Aligarh. And there were resistance for Sir Syed from people who were extreme conservatives. And beloveds, we are talking about pre-partition days, extreme conservatives who resisted this. And when Sir Syed went out to collect money, they said, we will give you money, but first show us that you can dance like the British. You want to make a university that is universal. You want to make a university that can compete with Oxford. You want to make a university that is of high intellect, etc. But why don't you first show that you can dance like them? And he bore this with fortitude. He bore this and said, whatever money you give, I need it for my university. I'll take it for my university. And that was the great sacrifice that he did. So then the next proposition I have is, how would your lordships, as your lordships are examining essentially fundamental rights, your lordships are looking at part 3, a fundamental right that the minority has been granted for setting up institutions. Whether that fundamental right can be cut down or not cut down by an interpretation, my lords, is what I am asking your lordships to consider. And in this, my lords, your lordship be good enough to turn to volume 5, 5C. A judgment. Well, it's 5B. Your lordship will turn to 5B at page 366. Paragraph 42, my lords, there are just 3 or 4 paragraphs that I will indicate to your lordships. My Lord Chief Justice's very eloquent description of the nature of fundamental rights. Because I want to pinpoint this because this would help your lordships then take a view on what to be done with the Article 30. Because if your lordship will just allow me to read a little bit,
Page?
because obviously in the context
What
of
page?
privacy, because the page is 366, paragraph is 42 in 5C.
Yes.
Well, your lordships have started with privacy because that was the issue before your lordships, the privacy as a fundamental right. Your lordships have considered John Locke, and your lordships have considered William Blackstone, etc., etc. And in paragraph 43, your lordships have summed it up. The notion that certain rights are inalienable was embodied in the American Declaration of Independence in the following terms. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that amongst these are life, liberty, and the pursuit of happiness. The Muller's life, as interpreted in Article 21, your lordship knows, goes far beyond the original text of the Constitution. Then, my lords, your lordship will be good enough to come to the bottom of 43 at page 367. In quotes, my lords, right at the top of that page, for its drafters to ignore, to forget, or to depreciate the rights of man are the sole causes of public misfortune and government corruption. These rights are natural rights, inalienable and sacred. The National Assembly recognizes and proclaims them. It does not grant them, concede or establish them. It was an interesting word, establish, used here. And their conservation is the reason for all political communities within these rights figures resistance to oppression. And then, my lords, Roscoe Pound in paragraph 44, the spirit of the common law. The quote is, natural rights means simply interests which we think ought to be secured, demands which human beings may make, which we think ought to be satisfied. It is perfectly true that neither law nor state creates them, but it is fatal to all sound thinking to treat them as legal conceptions. For legal rights, the devices which law employs to secure such of these interests as it is expedient to recognize are the work of the law, and in that sense, the work of the state. Then your lordships will see the next quote, which is on the classical natural law that's found in the revival of natural law. Second line, one was natural rights, qualities of the ideal or perfect man in the state of perfection by virtue of which he ought to have certain things to be able to do certain things. These were a guarantee of stability because the natural rights were taken to be immutable and inalienable. These words. The social compact, a postulated contract basis of civil society, here was a guide to change, an ideal law of which positive laws were only declaratory, an ideal body of perfect precepts governing human relations and ordering human conduct, guaranteeing the natural rights and expressing the social compacts. Well, it's the social compact of equality. It's the social contract of participation. And so social contract, as your lordships have seen, of life with dignity. And would your lordship then consider that the entire range of rights, certainly the rights of life with liberty, includes the right to educate yourself, includes the right to educate yourself with other colleagues and with other friends, and that rights should not be truncated by an interpretation of court saying this established. And there, my lords, your lordships already have what Mr. Kapil Sibal had argued. My lords, then 46, because this sums up paragraph 46 at page 368. Natural rights are not bestowed by the state. They inhere in human beings because they are human. They exist equally in the individual, irrespective of class or strata, gender, or orientation. So, my lords, this really sums up. Then, if your lordships will quickly look at paragraph 48, and there I believe, my lords, because this will link up with the article I wanted to place before your lordships, the idea that individuals can have rights against the state that are prior to rights created by explicit legislation has been developed as part of a liberal theory of law propounded by Ronald Dworkin in his seminal work titled Taking Rights Seriously. In my lords, next page, 369. Your lordship will then see page 369 at the bottom. This is Ronald Dworkin. Individual rights are political trumps held by individuals. Individuals have rights when, for some reason, a collective goal is not sufficient justification for denying them what they wish as individuals to have or to do, or not a sufficient justification for imposing some loss or injury upon them. Dworkin asserts the existence of a right against government as essential to protecting the dignity of the individual. It makes sense to say that a man has a fundamental right against the government in the strong sense like free speech, if that right is necessary to protect his dignity or his standing as equally entitled to concern and respect, or some other personal value of life consequence. And my lords, that I believe is what your lordships are now looking at in terms of the rights of the minority. Then, my lords, if your lordships will come to one more important 419, if your lordship will come to 419. Well, that's important because it indicates how your lordships have handled the issue of rights. 419. My lords, just before 419, if your lordship will come to page 408. This is the beginning of your lordship's discussion on fundamental rights, paragraph 120. Just above paragraph 121, I'll save your lordship's time in reading everything. Well, the last 3-4 lines, the fundamental rights, in other words, are primordial rights, which have traditionally been regarded as natural rights. In that character, these rights are inseparable from human existence. They have been preserved by the Constitution, this being a recognition of their existence even prior to the constitutional document. So, Mullahs, I would argue that these rights that minorities have as individuals existed before 1950. And if in the 1950 translation of those rights into the document would in any way truncate them, then your lordships would consider whether there are possible ways in which that truncation can be avoided. And in this case, it is only a matter of interpretation. It is not a matter of voiding any portion or rewriting that portion, but merely a matter of interpretation given by 5 eminent judges of this court to see if that interpretation could itself be altered to give more meaning to natural rights and to human rights. Well, Lords, 418 is where your lordships come to, having considered all the general fundamental right cases, your lordships come to what your lordships call discordant notes. Well, it's in the entire thesis that Dawkins has, Dawkins' thesis of how to look at institutional interpretation of rights. He also has a significant section which talks about the mistake, a mistake that must be corrected, a mistake that must be restricted at an appropriate stage. And here your lordships are considering ADM Jabalpur as a possible mistake. And then if there is a mistake, what is best to be done? Your lordships considered what the majority had said. Then at page 144, your lordships come to the dissenting opinion of my Lord Justice Khanna. My lords, this is page 418. In his dissenting opinion, Justice Khanna emphatically held that the suppression of the right to move any court for the enforcement of the right under Article 21 upon a proclamation of emergency would not affect the enforcement of the basic right to life and liberty. The Constitution was not the sole repository of the right to life and liberty. ADM Jabalpur goes on even to say so. Then, my lords, if your lordship will just leave that paragraph 525, internal paragraph 525, and your lordship's comment then comes at the bottom of that paragraph. Even in the absence of Article 21, it would not be permissible for the state to deprive a person of his life and liberty without the authority of the law. Your lordships are actually saying that even in the absence of 21, because of whatever legislation or whatever the law that is being propounded, it will not take away your right to come to court to seek remedy. That was the critical decision in dissenting judgment that my Lord Justice Khanna gave. Then, my lords, at page 136, very quickly, at page 419, paragraph 136, your lordships held as follows. The judgments rendered by all the 4 judges constituting the majority of ADM Jabalpur was seriously flawed. Life and personal liberty are inalienable to human existence. These rights are, as recognized in Keshav and Bharati, primordial rights. They constitute rights under natural law. The human element in the life of the individual is integrally founded on the sanctity of life. Dignity is associated with liberty and freedom. No civilized state can contemplate an encroachment upon life and personal liberty without the authority of law. Neither life nor liberty are bounties conferred by the state, nor does the Constitution create these rights. The right to life has existed even before the advent of the Constitution. In recognizing the right, the Constitution does not become the sole repository of the right. It would be preposterous to suggest that a democratic Constitution without a Bill of Rights, would have individuals governed by the state without either the existence of the right to live or the means of enforcement of that right. The right to life being inalienable to every individual, it existed prior to the Constitution and continued in force under Article 372 of the Constitution. Justice Khanna was clearly right in holding that the recognition of the right to life and personal liberty under the Constitution does not denude the existence of that right. Apart from it, nor can there be a fatuous assumption that in adopting the Constitution, the people of India surrendered the most precious aspect of human persona, namely life, liberty, and freedom to the state, on whose mercy these rights would depend. Such a construct is contrary to the basic foundation of rule of law, which imposes restraints upon powers vested in the modern state when it deals with liberties of the individual. The power of the court to issue a writ of habeas corpus is a precious and undeniable feature of rule of law. And your lordships can consider various other judgments, and your lordship then finally overruled the majority as far as the habeas corpus case was concerned. Because I'm asking your lordships to consider whether the same perception would apply to interpreting the Constitution. I'm not asking that any part of the Constitution be held void. That would be a very far-fetched argument. But the integrity of the Constitution and the harmony of the Constitution in the sense of how it tries to represent primordial rights, my lords, would lead your lordships, I hope, to actually coming to a conclusion that the word established when it comes to minority rights of education is something that had to be considered liberally to include participatory functioning. Only the de jure regulation may come from the statute because it cannot come in our system from anywhere else. But that the purpose of the statute and the heart of that statute and the background history of that statute, of the act itself, would have to be considered. Well, Lords, then this is the fundamental argument that I'm placing before your lordship. But if your lordship would now consider going back to my written submissions, well, Lords, there is in what I'm saying is supported by the thesis that Ronald Dworkin places in his book called Freedom's Law, but it's reproduced here as it first appeared, the moral reading of the Constitution. If your lordship will see, this is at page 9 of my written submissions. Volume 1B. Right at the top, my lords, is, my lords, I'm emphasizing this because several of your lordships have in many judgments have indicated how Dworkin can influence decision-making in terms of how two conflicting views have to be harmonized and how the judge has to come to a conclusion. If I may just read that little bit here, my lords, in paragraph 1. There is a particular way of reading and enforcing a political constitution, which I call the moral reading. Most contemporary constitutions declare individual rights against the government in a very broad and abstract language, like the First Amendment of the United States Constitution, which provides that the Congress shall make no law abridging the freedom of speech. The moral reading proposes that we all, judges, lawyers, citizens, interpret and apply these abstract clauses on the understanding when they invoke moral principles about political decency and justice. The First Amendment, for example, recognizes a moral principle that it is wrong for government to censor or control what individual citizens say or publish, and incorporates it into American law. So when some novel or controversial constitutional issue arises about whether, for instance, the First Amendment permits laws against pornography, people who form an opinion must decide how an abstract and moral principle is best understood. They must decide whether the true ground of the moral principle that condemns censorship in the form in which this principle has been incorporated into American law extends to the case of pornography. Then, my lords, next paragraph, the moral reading therefore brings political morality into the heart of the constitutional law. But political morality is inherently uncertain, etc., etc. Well, Lords, then this article goes on to what are the alternatives to this moral view. I would argue, my lords, that this moral view that Dworkin has suggested is already reflected each time your lordships have said that there is a constitutional morality that we must submit to, initially known by way of constitutional values, but your lordships have now talked about constitutional morality. The political morality that Dworkin talks about is similar to constitutional morality that your lordships have applied. And constitutional morality looks at the constitution as a whole, not in pieces, etc., to arrive at an integrated idea. And I submit, my lords, that an integrated idea of constitutional morality would certainly point your lordships towards coming to a conclusion that minority rights can't suddenly disappear by way of an artificially restricted interpretation of a word like established. Well, that's basically my argument to essentially support what all the other council have argued, that this is an additional reason, the moral reading of the Constitution that would give your lordships this conclusion. I'm deeply grateful, my lordship.
Yes, Mr. Farah, sir.
As I am appearing in Civil Appeal 2316 of 2006, that's 701.7 before your lordships board. Because your lordships in this 7-judge combination are being essentially called upon to interpret the word established in Article 30 of the Constitution, and whether the meaning of establish as given by Aziz Basha is correct. Because if I have understood the core purpose of the reference. Well, as I'll begin my submissions by borrowing from my Lord the Chief Justice's observation today. Well, as how do we read Article 30? Do we read as something which creates a ghetto? Or is it for a larger purpose? Because my respectful submission, and I'll just flag two submissions of that, but just as an opening, I'll flag notes, is that in any country, a minority craves for two things, which Article 30 recognizes. And those two things are firstly, to retain its minority identity. And secondly, while retaining its minority identity, to fully and completely participate in the national life and national mainstream. In my respectful submission, Aziz Basha, apart from the specific reasoning, proceeds on the basis that you can do either one or the other. You can't do simultaneously both. So you can be a minority, you stay in your space, but if you become a university and the law requires the parliament to enact something, then you lose your status. You can't be both. If you have provisions in your statute which permit others to be part apart from the community for which it is being established, that may disentitle you. Plus, that's the background. Plus, the second background submission is that your lordships will bear in mind that AMU, today we are testing AMU status in 2024. In its present form, it has existed from 1920. 104 years. Even if we exclude the MAO portion. And then if we include that, it's 150 years. Plus, AMU is one of the main factors, if not the main factor, for creation of an educated Muslim middle class in India. It is responsible for it, and it continues to nurture it. If your lordships were to come to a conclusion that it's not a minority institution, my respectful submission would be that would gravely damage that role which AMU has played. Because with that background, my two submissions I'll just flag and then I'll go into them. Because the first submission is that the distinction between establishing an education institution and the device to bring it into legal existence is well recognized in our law, which has been completely ignored by Basha.
Distinction between
Establishing an educational institution and the device to bring it into legal existence is well recognized in our law, which has been completely ignored by Basha. Well, that's my first submission, my lord, which I'll seek to develop. Plus, any educational institution, forget a university, as your lordships have clearly seen, requires a statute. Any educational institution will necessarily require a legal device. A college, a constituent college may require something else, affiliated college may require something else, a school you will require registration. Plus, the logic of Basha is, and lordship saw that when Mr. Sibal was arguing, that was shown to the court, that the central legislature established the minority institution because the statute was passed by the central legislature, the imperial legislature. Established, and that's the meaning of established for the purpose of Article 30 of the Constitution. Well, my respectful submission is it conflates, obviously, establishment and incorporation. That it definitely conflates. But what it also conflates is established by and established through. It is established by a minority through the legal device of a statute. And Malas, this distinction is actually the fulcrum on which all private universities exist in our present day legal regime. I'll show that. Your lordships will just have volume 3I. I just want to show the distinction between established by and established through. Volume 3I, my lords, will have
Volume 3.
I for India, my lords. Page 3 of that. Well, this is a UGC regulation. It's called UGC Establishment of and Maintenance of Standards in Private Universities Regulation 2003. It begins at page 2, my lords, of volume 3I. I am referring to, my lords, the definition of a private university at page 3, 2.1. Private, my lords have that, all my lords have. Private university means university duly established through a state/central act by a sponsoring body with a society registered under the Societies Registration Act 1860. The law, the statute is the device. The establishing authority is the registered society, in this case, a sponsoring body. Well, that's the fundamental distinction in my respectful submission, which Basha misses. A statute can be a legal device, well as the highest form of legal device, undoubtedly. There can be lower forms of legal device. A registration certificate under a Societies Registration Act. That is also issued by a governmental authority. By the logic of Basha, that is also established by the government. Now, my lords will have this volume 3H. Just the private, well, the private university regime is based on a sponsoring body. Normally, my lord, it's a business house or it could be a charitable organization which establishes a registered society. They prepare a plan, they put it to the government of the day. The government either enacts an act bringing that university into existence, separate act, or there are states which have a regular one act and you add it as a schedule. So as you come along, you add one university after another as a schedule. Now, in that respect, my lords will have volume 3H.
What about 3.1?
My lords. That's right, my lords.
Shall be established by a separate state act.
That's-
Here, the preposition used is by,
That's right.
whereas in the definition it is through.
Plus that,
What is the effect?
well, the point really is that when established, your lordships are right, it uses by. But I'm trying to emphasize the larger principle that the legal instrument is only a device. Because obviously, let us, well, if Basha is right, let's test the proposition. Under Article 30, we are interpreting the word established. Every establishment will be by some legal action. Minorities can never establish anything, forget a university. Because it will be even if a college is there, it will be a registered society. The registration will be issued by a authority, established by that central government authority, registrar of societies. Instead of parliament, central, this is imperial, the finding is, it's the imperial legislature, instead of that will be established by registrar of societies.
No, but don't you think that
That's exactly, I'm so grateful to my lords. I'm just coming to that. Because in fact, the private university regime also has minority institutions within it. And plus 5 of those institutions are relied on by learned solicitors in his written submission. I'll refer to them. And all of them, in fact, support our point. So, my lords, with that, just come for a moment the UP Act. And that is in volume 3H. Kindly have volume 3H. Page 231 is where it begins. Kindly have page 234. 3H.
PH? 234.
Plus at 236, kindly have the definition of sponsoring body, AA. A sponsoring body in relation to a university established under this act means a society registered under the Societies Act or any public trust registered under the Indian Trust Act. Very similar, AMU was effectively run by a registered society, and Mr. Khurshid pointed out. Now, of course, there was those societies subsumed. Now it continues to exist separately, but it is established by the society through the device of the act.
Which is the provision you're referring to?
It's 2AA.
AA, yes.
At page 236. A sponsoring body in relation to a university established under this act. And Malaz Bill has section 8. Which is at 242. Because I am only arguing for the broad principle. I am not. Your Lordships will have 8. On the commencement of this act, the existing universities enumerated in Schedule 1 shall stand incorporated under this act. So, you can have something existing. A legal device incorporates it. Now, just have the schedule, my lords, at 261. Plus 261, there's a schedule. Above the schedule, it says 63. Notwithstanding anything contained in this act, the university established by a religious or linguistic minority of the state of UP shall continue to have the privileges as guaranteed under Article 30. Plus, this provision, in my respectful submission, is meaningless if Basha stands. Because Basha says the minute a legislation intervenes, you lose your status. So, Malaz, this provision obviously cannot, just like the High Court in the impugned judgment here has said, a parliamentary amendment cannot set aside the basis of Pasha, which is interpreting established under Article 30. Neither can this provision. Now, my lords, will just have the first, the Integral University Act. Well, these are examples which the learned solicitor only has given. I'll just come to his written submission. The Integral University Act, it's a minority institution. Serial number 5, Tirthankar Mahavir is a Jain University, also a minority institution. And my lords, over the page at serial number 27, Era University, Lucknow. That is also a minority institution. So the correcting means Era.
What is it?
Era.
Era, is it?
Era University, Lucknow. Now, my lords, will have the learned solicitor's written submission, volume 2B, page 51. Para 85.
Volume 2.
B for Bombay.
Page
51, my lords, para 85. My lords have that. Para 85. An analysis of legislations establishing other minority universities makes it clear that where the intention was to establish a minority institution, the legislature had included specific provisions in the Establishing Act itself to give the university a character of minority institution. Well, the first example is Sam Higginbotham University of Agriculture, UP. It says, well, at the bottom that established and administered by the Ecumenical Minority Christian Society, namely the Sam Higginbotham. Well, my respectful submission is, this is exactly what the amendment in 81 sought to do in the case of AMU. Plus, the 81 amendment which you lordships read yesterday, the definition of university that was established by the Muslim community, the 81 amendment is exactly this.
But his argument is not that. His argument is at the stage of establishment itself.
But that makes no difference for the reason. I quite see what the question is.
That's not his argument.
Well, but that makes no difference.
No,
No, I'm not putting an argument in.
argument as it is.
No. So, my lords, established and administered by the ecumenical minority. The proposition I'm placing for my lord's consideration is this. It makes no difference how the parliament or a legislature describes in the statute as to the formation.
There may be a flaw. Logically, there is a flaw. The flaw is because Article 30 uses the word established and administration.
Correct.
So you can't by a legislature, even if it is not established, create it. Because then there'll be conflict between the legislature and, in fact, you're countering your own.
No, I'm making the same. If I've understood my Lord Justice
Countering
Khanna's
your own
question.
argument now.
No, if I've understood my Lord Justice Khanna's question.
Yes.
My lord,
First, you raise the point that the statute cannot take away my right, which is under the Constitution, which is the right given to under the Constitution is to establish a minority university or an institution. The statute cannot take away that right. But now you're arguing to the contrary where the statute itself provides for it.
Well, I am saying the statutory amendment, be it in the case of AMU or be it in the case of this university, makes no difference till the time the authority in Bhasha stands, which is that the minute you legislate, you lose the status. So these universities all have to go too. It makes no difference that they describe it. That's the point I'm making. In support of these universities, the learned solicitor is saying that, listen, they say that it is established by the minority. But that's not the test in Bhasha. Bhasha says the minute a legislature intervenes, out you go. So everything goes. But I swim and sink with the examples the learned solicitor has given to support his case and against me. So the point I'm making.
So according to what the 1981 Act did was
Yes.
recognize this dichotomy. The 1981 Act recognized that the establishment of the educational institution was by the Muslim minority. The legal form which was given to it of incorporation was brought about by the 1920 Act.
Correct. So all I'm saying is that explanation really.
And by essentially what the 1981 Act has done is to recognize that as a matter of fact, the establishment was by the Muslim minority, though as a matter of fact, the form of giving it a legal device in the form of an incorporation was brought about by a statute.
That is correct. But the problem still remains, and that's why the High Court has struck it down. Your Lordship will have page 54. What's the basis on which the High Court strikes down that first university definition? Only on the basis that Bhasha means under the Constitution, established Article 30, established is equal to incorporation. Since you have a statute, therefore in the statute, what the Parliament says is irrelevant, therefore it has to go.
So to the extent that Bhasha equated establishment with incorporation,
Yes.
it was open to Parliament to adopt a varied approach by distinguishing the constitutional facet of establishment
Yes.
from the legal device of giving that establishment a legal recognition.
And that could have possibly been done only through a constitutional amendment. That's the short. So what I'm saying,
A legislative amendment.
constitutional amendment. You would have had to amend Article 30 itself because you are changing the interpretation of 30 as interpreted by Bhasha. So the only thing the parliament could have done is amend Article 30 itself, which it didn't do, and therefore it has been struck down here by the High Court. That's why your lordships are reconsidering judicially now whether Basha is correct. That's the short point for your lordships. So my submission is this: if Basha,
We have understood.
yes, so that's the first submission. So if Basha stands, then if there cannot be a minority university in this country, forget VMU, including the examples the learned solicitor has given. All of them will go. They have to go. If Basha stands, all of them have to go. I will go, but so will they. Because the second submission as a subpart of that is, because Article 30 interpretation cannot be hinged on the changing regulatory landscape of educational universities or institutions. I'll just give an example. The East India, before there was no Companies Act. As you lordship know, the East India Act, a company was established under a specific charter. Until 1844, when the UK Companies Act came for the first time, it was either through a separate act or through a specific charter of the Crown. Today, the position everywhere is that the Parliament can form a company, and the Parliament has enacted a Companies Act in which you can register. There are two simultaneous mechanisms. Something similar is happening on the university side also. Not exactly, but somewhat similar. Plus, these things keep on changing. UGC Act tomorrow can change, my lord. Your lordship, my lord Justice Suryakant pointed out, is that a problem? Today, of course, it's a problem. The way it's structured, it is a problem. But if tomorrow it says that you don't need a law for a university, Article 30 cannot be hinged on a changing regulatory landscape. That's what Basha has done by saying the minute it's an act to go out. It has to have an independent meaning, irrespective of how the law below the constitution is changing. That's the second error which Basha makes.
Yes.
Plus, then my other submission is something which was really not submission, but a question which arose from the bench. I'll just try to answer it in very short. Well, like Mr. Sibbal argued, and this is without prejudice to his argument, that once I have established, Basha knocks me out on establishment, then it's under the Article 30, it's my right to administer. If the Parliament intervenes through a law, I can say that's violating my right. To administer is my right the minute I'm shown to have established under Article 30.
That may not be fully correct, because even if a minority institution establishes it may not visualize the right to administer will be retained by the minority community.
Well, I agree. I just without prejudice, so I see the point.
So there is no question that the person who establishes will like to retain.
I am grateful, Malas. I'm extremely grateful. So this, Malas, takes into account.
That may not flow from the first proposition. Right or establishment itself will not lead to the conclusion that the person who is established or the community which is established is also the
Malas, so may I say it like this? There is no duty to administer, your lordships are right, but there's a right to administer. If I want to administer it through myself, I have a right to do it. But there's no duty that I should administer it only through myself. I can do it like Mr. Sibbal argued to somebody else.
That's a different.
That's the submission.
That's a different argument.
Yes. So, Malas, once I have, Malas, so there's a duty and there's no obligation that you must continue to administer through yourself.
You are in fact yourself now accepting establishment may be by one person, administration may be by another person or a community.
Because I am only saying this without prejudice to his argument, but I'm just, your lordship will allow me to make the submission just for a moment. Because the minute there can be today, what is the legal regime? Without going into the details. Well, let us assume it's a legal regime which does not aggressively exclude others from participation in the university. That's the point. It doesn't say people who are not Muslims will be limited to 5% or 10% or 15%. right? That's what. But can that ever be determinative? Once I have established it and I am de facto actually running it, a neutral regime does not impact my de facto administration. A legally neutral regime, the regime which can become problematic, which will infringe my right, will be this. If the parliament tomorrow says that you, Mr. AMU, cannot have more than 20% Muslims in your EC, I'll immediately challenge it. Although I need not, but I will immediately challenge it, saying, listen, I want to administrate through myself, you're violating it. But a neutral regime which doesn't reserve seats for Muslims, till the time I'm in de facto control, does not at all, I'm in administration today, the present regime does not, legal regime, does not in any way impact my day-to-day administration. I'll show that in a moment. In court, in EC, in academic council, Muslims are in overwhelming majority. With the present legal regime, why do I need to challenge it? So a neutral regime, a regime which does not, in a secular country, I am an institution of higher learning. If in a secular country run by a constitution, I have not aggressively sought to limit others, will that be a point against me? Even though factually I'm in complete control and there's no risk of losing that control. On that, just some data. Your lordships will have volume 3C. Volume 3C, your lordships will have page 551. Page 551 of volume 3C, C for Calcutta. Plus first is AMU court composition. Plus this actually 51. This is, well, this has been filed by the university itself before your lordships. I'm just taking your lordships through it. From 19, this is the court, the actual composition of the court in terms 551. Yes, lordship. So it has taken all the different appointees, how the people in the court are appointed, different provisions on the left-hand side, and then said from year to year how many Muslims and non-Muslims were there. M and NM is the plus indicator of Muslims and non-Muslims. Plus 1983, your lordships will have at the bottom straight away. Total. I just want to show the total. Plus 165.7. This is the court. This is the supreme body as even Basha recognizes. And this is 81 onwards. 152.7, 152.11, 95.15, 137.15. Plus this ends at the latest 223 your lordships will get, 2023, at page 557. At the bottom is total. Again, 2018 is 147.15, 129.20, 75.15. That is still 82%. So, Mullah, at no point in time for the last 40 years, the court has had less than 80% Muslims, de facto control, despite the legal regime, whatever it may have been. Why do I need to change the legal regime and aggressively prevent when all my feeding bodies to the court are ensuring that the composition does not change, that the minorities are in control, in fact. And this is, well, I've showed the data for 40 years, but your lordships may take it. This is the status for 104 years, undisputed. Now, my lords, kindly have page 558, which is EC, Executive Council composition. Plus 558, the next page after. It's 558, if your lordships will have it. Next page, 558. Plus this is the EC composition from 83 onwards for the last 40 years. At the bottom, your lordships will see M16, NM4, 16.4, 15.4, 22.5, 17.4. 80 to 95% is the range. Your lordships, this ends. Just kindly have 564 for a moment. 563 first for a moment. Page 563 at the bottom. In years 2015 and 16, 21-0. 27-0, 27 Muslims know this thing. That's not something to take pride of, but the point I'm saying is that by and large, 80 to 100% EC, which is the primary executive body, is in de facto control of the minority. So court I have shown, Mullahs, Executive Council I have shown now. And this is with a completely secular regime, which doesn't positively say, oh, so and so has to be limited to 5%. Plus now the Academic Council, which is the third body. Plus court, EC, AC are the three bodies which run the university. Now the third body, which is the Academic Council. And that your lordships will find at page 565. Plus at the bottom, Muslims 102, non-Muslims 113. This is 83. Again, Muslims 102, 13, 91, 14. And this ends at 572, the current position. Your lordships will have the current position in 2023. 136.7 as of today. Academic Council. And the reason for this is this: the way the EC, AC, etc. are the feeder mechanisms for this are in effect old boys societies, alumni societies, other minority institutions, etc. So it's ensured. So the fact that I positively, aggressively do not discriminate in my statute against others is immaterial. Because with that legal regime, I am ensured a de facto control There's no threat today with the existing regional regime of losing the de facto control. The thing which will be problematic, like I said, if the parliament says you can't in your EC have more than 20% Muslims, then I'll challenge it. But a secular regime doesn't impact me. That mixes up secularism and right under Article 30. That actually blends in very well with the scheme of the constitution as to what's the meaning of. I don't need to aggressively remove others in my document to show that, oh, I'm minority. Only if I positively exclude aggressively everybody else. So once I'm established, unless I, who have a right to then administer, feel threatened by any provision, I continue to administer the institution also. Your lordships will not just check provisions therefore and say, oh, because of this, you are excluded, therefore it's a problem.
You're not aggrieved by therefore, neither the 51 or 65 amendment.
Plus 65, really, 51 people challenged when all Muslim court was changed to a secular provision, really speaking. But Basha itself recognizes that on the ground, nothing changed because of this mechanism.
My question is not that.
Really speaking, today I'm speaking for the petitioner. I can't, of course, speak for everybody. Speaking for the petitioner I represent, I'm not agreed by that. I'm not agreed by that. And the present dispute arises, just one detour, present dispute arises in the context of reservations. That's the next data. I'll just quickly put it and then.
That is a separate question altogether.
No, but how does, this has come to your lordships? Why this dispute arose in 2005.
If you're wanting to go into that question, then we'll have to.
No, not just, I'm just flagging something. I'm not at all going to address it on merits, not at all. Just flagging one point. The present dispute only arises not because of any provisions really in that. What happened, 50% reservation was given, and only reason to give that was in the professional schools, Jawaharlal Nehru Medical College, a very sought after college. The distribution, for instance, is almost 50-50 between Muslim and non-Muslim. Sometimes it can be 45 also, Muslims go to 45 sometimes. So there the idea was to protect that to 50. Otherwise, in the rest of the university, I have the data here, 70 to 80% student body is Muslim. The need for reservation, that's how the present dispute arises, only in the context of professional, highly competitive spaces, medical and engineering colleges, lordships know anywhere is highly competitive. That's the space where there was basically a reservation was brought in. Otherwise, reservation is not even needed because 70 to 80% of the student body is anyways Muslim.
You have St. Stephen's College, you have DMA Pi, Xavier's in between. So don't go on that. If you go on that, we'll have to.
Well, the test in Stephens would have come to my rescue even if I was not in this position. All I'm saying, I don't even need that test necessarily, is my submission to your lordships, given my situation. Of course, if I was worse off, the test would still help me, no doubt. But just if your lordships will permit, one page if I can hand over, if lordships will permit, just the data and then of the composition of the student body.
Stop for them. I will drop. 5 minutes. Then we can take.
Plus the total students today in the university is 23,675. Out of that, the Muslim students are 18,700, which comes to percentage of Muslim students 77.39%. Percentage of Muslim female students out of all the women students, 81% are Muslim. Out of the male students, 79% are Muslim. And the overall composition, 77.39. That's how it comes. So, the control on the administrative side is substantial. It's catering to the Muslim community in substance. It also takes everybody else in alignment with the secular ethos of the constitution without aggressively discriminating against it. Can that be a point against me in a constitutional adjudication? That I cease to be a minority? That's the submission on administration. That's my final submission. This university has served a very important purpose of creating an educated Muslim middle class. It has literally created, I don't intend to exaggerate, it actually has education of Muslims and AMU go hand in hand. And the reason is the minority status is very relevant for that. Well, this is recognized in many judgments of your lordships as well. I'm not going to take you through them. But the point is this. Students from Bengal, from Karnataka, from Kerala, from Muslim families will send their children only to AMU. They may be today, they may not 100 years back, they may not have been great universities, but today they're exceptional universities all over the country. A Presidency College is there, Calcutta University is there, in South Malad we have, but lot of, that's the composition, I could not place it, but the composition of AMU is from all over India. Because of its minority status, because that minority identity, which I started my submissions with, is relevant to a minority. That's why we have that Article 30. And this is especially true for women students, because the burden of bearing the cultural markers of identity, be it a majority or be it a minority, always comes on the women. And when it comes to girl education, the existence of the minority status of AMU is very relevant. It's a very important consideration in families sending their women to this institution and possibly to access higher education at all. If the institution ceases to be a Muslim minority institution, it may very well hamper the education of Muslim women in India, higher education of Muslim women in India.
But over the last 100 years, without the minority institution tag, it has continued to be an institution of national importance.
Plus, de
How does
facto,
it matter that if we are not with you on Bhasha, you started your address by saying this, that it would create great damage.
plus
Without the minority tag, institution has continued to be an institution of national importance.
So, may I-
How does it matter
yes.
for the people whether it is a minority institution or not? It's only the brand name, AMU.
May I try to answer that? Because although Bhasha came, until Bhasha it was considered as a minority institution, Bhasha came, 81 amendments sought to undo it. Thereafter, this has been litigated through. There has always been a stay, in effect, except on the reservation aspect. The 81 amendment, to the extent it sought to clarify the establishment and therefore the minority status. In my submission, wrongly so, it couldn't have done it, but that doesn't matter. There's always been a stay. So really speaking, today, because of the operation of the status quo orders of your lordships on the 81 amendment, it continues to be a minority institution. In fact, if your lordships uphold Bhasha, for the first time clearly now, it will become a non-minority institution.
The last argument may have a counterpoint. We're not going into that. There'll be a counterpoint.
That's fair enough.
That's a more.
My
of
submission
a-
is this, that a minority,
That may not be a purely a legal argument.
it may not be, because your lordships, when you are interpreting established under Article 30, your lordships will take the social circumstance in some level of account. Of course, it's not a purely legal argument. If something can promote Muslim girl education possibly and ensure the minority status, well, there's no harm in it. In a secular,
Women is, they are studying everywhere. Let's not belittle them. They are studying in every.
because I'm not
corner of
belittling
the-
anybody.
Not because of.
It's a fact in the community.
Yes.
It is a fact in the community. Your lordships, I mean, these are sociological aspects. So of course, your lordships will not make a judicial finding on it, but it's a fact that communities send their children generally and women specifically because of the minority status. It's a fact. Plus, finally, so what I would submit, just I want to read out three, plus there is a very illustrious list of women, just want to place, women alumni of AMU. Plus that is there in, if your lordships will have my written submission, para 24, this is volume 2B. Plus page 35, in red page 35, running page 35. 1B, I'm sorry, 1B, my apologies, no, it's 1B. 1B, page 35. In para 24, in 1937, the school was upgraded to AMU Women's College. Notably, the AMU's Women's College was established at a time when the literacy rate among Indian women was just 3%, and almost 2 decades before premier women colleges such as LSR came into existence. In this manner, AMU became a catalyst for empowering Muslim women, breaking societal norms and contributing to the broader movement for women's rights and education in India during the early 20th century. The university's commitment to gender equality and educational opportunity laid a foundation for the advancement of women in various fields, contributing to their socio-economic and intellectual upliftment. The success of AMU is therefore inseparable from the triumphs of Muslim women in the subcontinent who have excelled across diverse fields. Among these are trailblazers such as Rana Safvi, a distinguished historian, Ismat Chugtai, your lordships are aware of Lihaf, a renowned novelist, Hashima Hassan, a notable scientist at NASA, and renowned educationist Najma Akhtar. These accomplished women have made significant contribution in areas such as law, education, politics, literature, and activism, underscoring the broad spectrum of talent that AMU has fostered over the years. In fact, even the first chancellor of AMU was a woman, Sultan Jahan Begum of Bhopal. The appointment of a woman as the inaugural chancellor marked a significant historical milestone. It was the first time a woman served as the chancellor of any Indian university. So, Manoj, the point I'm making is the minority status and the women education have gone somewhat together. And it has really fostered, Manoj, education amongst Muslims, in particular Muslim women, and that can be impacted potentially. And Manoj, finally, I'll just conclude my submissions with something, Manoj, I saw in the union's written submissions by the learned solicitor. Manoj, the broad width of that submission is that you are such a great institution. You are so good, you are excellent, you have faculties across the board. How could you be minority? No, it's not, I'm paraphrasing it. I'm certainly paraphrasing it. But the point is, it is an institution of national importance. It is an institution of national importance and a big institution. It's an institution of excellence. And somewhat that leads to the fact that you are not a minority. My respectful submission is that AMU does what Article 30 requires of minority institutions exceptionally well. That should not be held against it. The fact that I'm a successful minority institution cannot be the basis for making me move out of that minority zone. So this is on the aspect. Also on entry 63, final conclusion. Entry 63, national importance, institutes of national importance, just on that final submission. A minority institution can be an institution of national importance. There's nothing. It's not as if only the majorities can establish institutes of national importance. Well, that's my final submission. I'm extremely grateful for that.
Thank you, Mr.
Leonard,
Thank you, Mr. Parasar.
Only one question. Is there any other institution, minority institution in the country, which is 100% funded by Government of India?
I cannot perfectly answer that because I don't have the data, but my understanding is that most minority institutions, including Jamia Millia Islamia, for instance,
100%.
100%, substantially, nearly 100 it would be, exact numbers I can't, but substantially funded. Even Jamia Millia Islamia in Delhi, which is established under the 87 Act of Parliament, will almost be nearly 100. I can't vouch, of course, exactly 100. I'm grateful.
Lordship, whatever time I am left with, Lordship may permit me on two aspects. One is how Anjuman Rahmania approached your Lordship in 1981 and how finally that petition was disposed of. Despite on 26 November 1981, Honorable 2 judges referring the matter to 7 judges. So first, your Lordship may have the reference. I need to read few lines of that reference because it is important. Your Lordship may have 3A 209, volume 3A 209. I have placed that writ petition also on record, my lord, of 1981. The circumstance due to which that petition came to be filed. 3A 209, if your Lordship has, at the bottom, your Lordship has recorded
About 15 minutes or so.
If your Lordship gives me 15 minutes today, I'll be able to conclude. Otherwise, your Lordship may give me next day.
Shamsad, we don't want to rush you. You take your 10 minutes or 15 minutes after we come back. Next week, we are not sitting.
I'm so deeply obliged.
Hmm?
I'm
Then
so
we give you-
deeply offended.
Then now, we'll be sitting on the 23rd for this matter. We'll give you 15 minutes, but keep down.
I'll not exceed 20 minutes, my lord. 15 to 20.
15 now.
I'm so deeply offended.
This is not this time. Touched by the fact that you are rising, so we'll give you a little time on
I'm
the
so
ground.
deeply offended.